Hello, everyone. Welcome to Preempt. And we're going to talk today about something that is always in the news, and that is discrimination. So we're going to talk about what discrimination is. How do you file claims of discrimination? How do you defend against claims of discrimination? Just basically top things you need to know about discrimination. Because there is a lot of misinformation that is being put out about discrimination and so forth. And so I'm joined today by, of course, myself. I am Wanda M, President and CEO of Preempt, and I'm joined today by Dorian Morley, who is our Senior EEO Advisor at Preempt. Hi, Dorian.
Hi, everybody. Hi, Wanda.
And also Susan Broek, who is our digitizing expert as well as our senior EEO investigator. So she's going to be giving us some tips that you can use to, to defend against discrimination claims as well as to bring discrimination claims. So anyway, without further ado, we're going to get started. So before I say what discrimination is in general, I will just say this. Our industry, the EEO industry, is connected to history. All right, so we can trace our history all the way back to biblical times. And then after that, we can trace it back to the Declaration of Independence. I think I got that right. Declaration of Independence. All men are created equal. And then we have the Constitution, the 14th Amendment to the Constitution that contains rights against discrimination. And so from there, we have Title VII, which is the statutory law that we do our work under pursuant to Title VII when we handle those kinds of cases. So it is a very, very old, we're connected to history. And that's something that we're very proud of. Now, I will say this too, before we get to the legal definition of discrimination, which Dorian is going to go through and explain it so eloquently. First, I'd like to say, we are not diversity, equity, and inclusion. We get confused a lot with that. We are not. The two are different. And people that do DEI or DEI, they will tell you that. Okay, so first and foremost, we are the law. We are based upon legal authority with discrimination. So that means you have to meet these legal standards that we're going to go through today because it's important that you know what those are. Whereas DEI is mainly based upon policy. As you could see that what has happened recently with DEI, because it is a policy, it could be rescinded and changed at the drop of a hat. Whereas Title VII civil rights laws, they cannot be. I mean, they are codified in the law. So it's very difficult to overturn these laws. The most that we have had happen is, I know there was an executive order dealing with discrimination that was rescinded, because that's something that the president can do. But Title VII is not something that can be wiped out by an executive order. So we want to make that point clear, because sometimes we also do training in this area, and we have people that have signed up to become EEO investigators. And then when they get in there, they say, oh my gosh, this isn't what I thought it would be. And they are very disappointed. So think of us like the law. That's who we are. And we're going to go through some legal standards. So Dorian, why don't you just tell us in general, what is discrimination?
Well, it's discrimination is unfavorable treatment, being treated unfavorably. And in this case, it's based on your protected class, which is defined by law.
Right. And you notice the key word Dorian talks about, law, by law. Okay. And then you notice it goes into when is it illegal? And that's the key. Somebody can discriminate against you, but that doesn't mean that you have a case under the law, because it has to meet the law. So just because somebody treats you unfairly or whatever, if it's not based on law, any of these categories and bases that we're going to mention today, then you cannot prevail. That's what this is. So you have to understand that. So anyway, that's pretty much it in a nutshell. Now, we're also going to talk about the key discrimination laws. The biggest one that we deal a lot with is Title VII of the Civil Rights Act. And this is something that was born out of the civil rights movement. And that includes, Reverend Dr. King and the entire civil rights movement and so forth. And it was signed into law by President Johnson. All right. So keep in mind, this is federal EEO laws. Now, state and local jurisdictions can have broader civil rights laws than what we have under Title VII. And one of the things we always talk about is the damages that are available under Title VII. You're not going to get $1 million. Okay, I'm just going to keep this straight. I'm going to give it to you straight here. If you have a claim of discrimination and you think you're going to, and you may prevail, you're not going to get $1 million because we have statutory limits under Title VII. Now, if you see other discrimination cases in the news and somebody's suing for $1 million and they've got multi-million dollars or whatever, you can rest assured it wasn't solely brought under Title VII, because Title VII has a cap of $300,000, right, for compensatory
damages.
and
You can
punitive.
get other damages like back pay and
right, but they're not going to be there might be $1 million, depends on what job you have.
That'd be a big job.
Yeah, it would be a big
Very
job.
big.
SES, maybe a SES senior executive service position, I can see. But general, right, everyday working people, it's not going to be $1 million. It isn't. And then they have punitive damages, and the punitive damages are capped at 300 also, right, Dorian?
Right.
Okay, cool.
I think it's important to say that all of these laws deal with employment. We're talking about issues involving employment, either as an employee, as an applicant, sometimes as a former employee, but they're under the umbrella of employment.
That's right. That's a good point. Sometimes independent contractors, and that's a fine line. Let me say that. That's a fine line because people have been misclassified for years. Someone may say you're an independent contractor, but you're really an employee. So most people that I would dare say, a lot of people that are classified as independent contractors are pretty much misclassified. They really are employees masquerading as independent contractors, except I would say in our industry, because that's industry practice where mainly we hire independent professional contractors. Most of the times they are, but you can violate that law and make them employees. So it is a very fine line. So I would just preface it with that to say that there are instances where independent contractors are misclassified as employees. And that's the big carrot about that too, because when you're not an employee, you don't come under the protection of all these great laws that we have. And that's a major concern. All right. So Dorian, why don't you just give us an overview of these important key civil rights laws?
Okay. So as Wanda said, the big one was the Civil Rights Act of 1964, which has been codified under Title 11, Title 7. I'm tongue-tied today. Sorry. And it identifies several protected categories: race, color, sex, and sex has later been judged by the courts to include gender identity, sexual orientation, and pregnancy by different laws and decisions. It covers religion, national origin, and also later decisions have brought into it harassment, and retaliation or reprisal was also originally covered. So that's the big umbrella civil rights law. There have been additional laws passed, including the Age Discrimination and Employment Act, and that covers individuals who are 40 and older, protects them from discrimination. The Rehab Act of 1973, which was later modified with the Americans with Disabilities Act and the amendment to the Americans with Disabilities Act, which covers disabilities and medical conditions to protect those employees, applicants, former employees, some contractors from discrimination based on a certain medical condition. And the most recent one is the Genetic Information Non-Discrimination Act, which protects those with certain genetic conditions from being discriminated against, perhaps like a family history of cancer, or the myriad genetic components that people may have that may cause the employer to be concerned about risk when hiring them or employing them.
Okay, cool. All right, so let's just briefly talk about two other ones: harassment and retaliation, up under Title VII. Yeah,
okay.
Go ahead.
So harassment came into play. Gosh, when was I can't remember the year.
That's okay.
But it started out with sexual, it's been quite a while, sexual harassment.
Right.
When sexual harassment first came to the fore, and it has been broadened to include harassment based on any protected category.
Exactly.
It can be harassment based on age or pregnancy or whatever. We find that harassment is very often claimed, and it's very different than disparate treatment. Harassment has certain, and we're going to talk about this in a minute, but to prove a claim of discrimination, you have to meet all of the standards of proof. And those have also been legally defined, and there are very specific standards for all of the theories of discrimination, including harassment. But they're different than disparate treatment.
Yeah. And the thing I want to say, two types: quid pro quo, this for that, harassment, and that was usually in the sexual context. I've never seen quid pro quo of the others, but anyway, and hostile work environment is the biggest part of harassment. You have, like Dorian said, you could have a hostile work environment component under all the other Title VII categories. And also the thing about that one, the hostile work environment one, the government has such a thing as non-Title VII harassment, which is kind of like bullying. So think of bullying. But on the private sector side, you generally don't see those kinds of claims, but because the government has a mass administrative system, they have policies that prohibit harassment in the workplace, period. So think of bullying and whatever. So, okay. And the last one I'll talk about, which is very important, is overlooked a lot. I shouldn't say overlooked. It's kind of the easiest one. I wouldn't say the easiest. It's the easier of all of them to prove is retaliation, because a lot of times when someone files a regular Title VII claim, let's say, based on national origin, sometimes the original claim can be weak. But then during the period that someone has this claim pending, there can be some type of retaliation action taken against this person that would justify retaliation. So I've seen a lot where the retaliation claim will stand, is stronger than the original claim, because it's so easy to violate. I wouldn't say easy, but so easy to trigger a retaliation claim. So that's important too. Okay. So, okay. Anything else you guys want to add, Susan? Anything you want to add about that based on what you've been seeing recently with the cases that you've been working on?
I think one of the things that's important for the complainant to remember is it is always your burden to make your case. And so many times, by the time we get to a formal investigation, you've told your story numerous times. You feel like, I've already said this. This is the important part, the investigation. It is important that you lay out your case and get all your points in at this juncture. That's the one that can move forward.
Okay.
And complainants can really benefit from understanding the standards of proof and knowing what is required to prove discrimination.
Absolutely.
Yeah, it's like playing a game of chess, point, counterpoint, point, counterpoint. We're going to go through that. Okay, cool. But the complainant, the one who files the claim, is the one who puts everything into action. because, if you don't have the claim, then that you don't have any reaction from the management side. All right. And we just briefly talked about Title VII. And some of the things we really want to point out with this is that it does prohibit discrimination based on a protected status. And we mentioned those earlier. We'll mention it again: race, color, sex, age, or national origin. And also retaliation and harassment as well. It's unlawful to discriminate against any employee or applicant, like Dorian said, in reference to your terms and conditions of employment. It prohibits discrimination. It prohibits decisions based on stereotypes and assumptions about abilities, traits, or the performance of individuals of certain racial groups. That's a big issue too. Somebody could say, hey, I was discriminated against because I was married to a white man, and my supervisor knew that, and so discriminated against me. Also, policies can be enacted that discriminate against particular
groups. Wanda, we can't hear you.
Okay, can you hear me now?
I can.
Okay, cool. Yep.
Oh, mine is yours. Like real slow. Okay.
Okay.
Cool.
Yeah. Okay. No problem. No problem. Yeah. So anyway, yeah. So it could be based on stereotypes and so forth, and policies that appear neutral on their faces can discriminate against a particular class. Now, the key thing here to remember, it has to be under a protected category. It does. And also keep in mind, under state laws, that they can enact broader protection. So they can say you can't discriminate against someone based on political party. Yeah, okay. So like in DC, all right, so you can't discriminate against someone because they may be a Republican and you don't want to hire Republicans. That's illegal in DC. And I know people laugh at that. They're like, wow, that's really something. But it is true. And of course, DC, of all the places, that's why they enacted it. Enacted it there because, I mean, politics. But yes, so that is illegal. Now, that's why I said state. I didn't say federal. So the feds, they do that. They bring in whoever they want to and so forth. But yeah, under state DC's laws, you can't do that. So anyway, ladies, did you want to add something else to that? Okay. All right, so let's go on to the next one here. That's important. Okay, here we go. This is the meat. Okay, now you heard Dorian and Susan mention earlier about the complainant's burden. All right, and so Dorian, want to talk here about say something about this. This is key.
Every claim is examined through the analysis of the prima facie case. With McDonnell Douglas, it's also called the shifting burdens. It starts with on its face, that's what prima facie case means, right? On its face, it could be discrimination. For example, if I apply for a job and a man is selected, so I could have a prima facie case of sex discrimination because someone outside of my protected group got the job that I was interested in and applying for. Then the burden shifts to management to say why they made the decision that they did. For example, we selected George because he had more experience and better appraisals than you did. And then it shifts back again to the complainant, who, if the complainant can show that, in fact, she has more experience than George and her appraisals were better than George's, then it can show an inference of discrimination because the management has not been accurate in their response. It's looks like a pretextual response, pretext for discrimination to prove. So that's the analysis that happens for every claim of disparate treatment.
Every claim. That's right. You heard she said, and that's true. Every single claim has to go through this analysis. So in the government, we have it where somebody files a claim and it'd be probably multiple claims. And so for each one, the complainant has to prove this. Yes. Okay.
Right.
Let's
So,
talk.
for
Yep.
example, I'll give you just one more example. If I
Sure.
had claimed a discrimination based on sex, female, and race, white, and George was also white, I would not meet the prima facie case standard for that claim because George was in my protected group for race, even though he wasn't in my protected group for sex. So it
Yes.
does matter. The basis or the protected status is also important.
You know, I just want to say something here that most people don't realize about the federal system, the way it's set up, or any, I should say, any discrimination laws, state or whatever. You don't have to prove physically, factually, your race. Okay. You like if I claim I'm white and I mean physically I may not look white. That's not the test. Nobody says, okay, give me your card, your birth certificate that shows you are actually white. That doesn't happen. We take you at your word. I think that is just so, that's just so interesting.
But
But
you know,
yeah,
it would
that's
be
true. It would
the
be a mess.
questions would be for everyone around you.
Right.
Was it their understanding that you were white?
Yeah.
And was there any
Good.
history that
Yep.
indicate that if you worked for the NAACP or if was this an honest, was this a true identification of yourself, by
Yeah.
yourself? But
Mhm.
you're right.
Yeah.
Yeah, anyone can say they're anything.
Yeah. Yeah.
Yeah.
So, go ahead,
The
Susan.
rest of the rest of the people's perception is what
Right.
matters. So if I think that you're white, that makes your point. If I don't,
Right.
then there's more
Right.
investigation. Yeah.
Exactly. And that's what the complainant has to prove that. There you go. We
Right.
get back to the proof. So, but you can say it though. That's right. You can
Right.
say, yeah,
Right.
right. Like sex, same thing with sex. Nobody actually physically cards you. Nobody actually looks at your birth certificate and says, I just
Unlike sporting events, no, you don't have to
right,
prove
right.
it.
They don't. They actually don't. And so that's what I just think is so unique about our laws. Yeah. So, and the other thing I want to say here too, that we're not going over today because it's already online, is the federal timeline, the timeline process that comes with all of this. Our laws have strict timelines. So every move, there's a timeline set. Somebody has to file, somebody has to respond. This has to be done by a certain date, a certain time. So we have strict time requirements for all this as well. So again, that's why I said, you have to do this in accordance with the law. And they are very, very strict on those timelines. Yes. All right. Let's talk about the defense, Dorian. Okay. So how about from the defense standpoint? What do they have to do?
Well, they have to have a non-discriminatory reason for their
Mm-hmm.
actions, a legitimate actions, in which I explained that in this example I gave, they would have to show what their true reasons were
Mm-hmm.
for selecting George. And it doesn't have to be, it doesn't have to make sense to anybody else, but it can't be discriminatory. If they decided that they wanted George to, I don't know,
Well,
but
say
go
for
ahead.
instance, maybe an example would be that I never let anybody take off the 5th of July. Okay, maybe unreasonable, but
Mm-hmm.
that is a non-discriminatory reason why I didn't approve your leave request for 5th of
Yeah,
July. And
right.
everybody, that happens to everybody. That's
Mm-hmm.
the kind of thing. And believe me, people, they are schooled and management. It doesn't have to be a regulation or an agency rule. It just has to be and articulate a reasonable reason of why. For instance, I don't let anyone take the 5th of July off because it's a very
Mm-hmm.
busy day. Or I
Mm-hmm.
never, at the post office, I never let anybody take the day after Thanksgiving. It's too darn busy. Those are,
Yeah,
maybe you're not happy about them, but that might be the rule.
right. Very good. Good point. Key point. That's a good point. Yes. All right. All right. So that's defense's burden on on that. Let's talk about pretext, Doria. How about that one?
Well, if the management official says I never let anybody off on the 5th of July
Mm-hmm.
and come to find out that they've never let females off on the 5th of July, but the record shows that there is a good close-knit group of males that always get to take off the 5th of July, then the complainant can show pretext. It has to, it's putting holes in their argument, basically.
Right. Another one that might be, you might be able to make your case. For instance, a retail store says, government that has a retail outlet, they say, all males have to work the day after Christmas because we have to take the Christmas decorations down. Well, that might make a case for the fact that why does it have to be males to take the Christmas decorations down?
Good point. Yeah, right.
Yeah. Okay, cool. All right, so let's move this along here. There we go. Okay, so we're gonna move this along. All right, so let's talk about the bases and claim, because that's the big piece. Go ahead. All right, so each EO claim must have two components: a basis and an issue. The harm equals the claim. Bases, the reason for the alleged discrimination, the protected status, that's the why.
Right. We've been using the word protected status instead of basis, but it's the same thing.
Yeah.
The basis is the protected status or the protected category. It's one of those types of individuals, that has been defined by Title VII and the other laws as constituting protected status. Right. Race, color, national origin, age, sex, etc.
All right, cool. And then here's the issue: the alleged discriminatory conduct or occurrence that resulted in an actual harm. The what?
Right. It's what happened. Right. The issue is what happened. Issue is also called the claim. In the pre-complaint, it's called the allegation. So it's what happened, according to the complainant.
Exactly. Okay. We mentioned earlier about disparate treatment. So to prove discrimination under Title VII, you would have to show disparate treatment. Okay. And that's the theory that we're talking about here. Most of the cases are processed using that theory. And that just means, like Dorian has said earlier, that the person was treated less favorably than similarly situated individuals because of their protected status.
And it can be more, by the way. A complainant can identify several protected statuses, I guess. It doesn't have to, it's not just one. We keep talking about one protected status, but it can be a group of them.
Right. And keep in mind, we're just giving you a general overview. We are not practicing law here. We are just giving you the basics of how the discrimination cases are processed and so forth. So you understand your burden and so forth. You're, free to Google online and read more about discrimination and so forth. And we also have courses that that prepare you to become an investigator or a counselor, so you understand how these cases are processed. And we've had people that have actually taken our certification courses and represented themselves in their own claims so that they would better understand how to put their cases together and so forth. So that's the purpose of what we're doing today, just to educate you, give you the basics of this. All right. And earlier, Dorian mentioned that you have to establish the prima facie case and so forth. And here we set it out. To establish prima facie case, due to disparate treatment, the complaint must show you're a member of a protected group, you were subjected to an adverse employment action, and there is a causal relationship between membership in the protected class and the adverse action. Okay, so I'm going to let Susan talk about this here because she sees this a lot. I'm going to let her talk about what she's seeing with complainants when it comes to this, making out the prima facie case. I think most people probably get it off the first one or two, but that third one, the causation, is usually what trips them up. But go ahead, Susan.
Yeah, it's fairly easy to meet the prima facie burden. Everybody's a member of some protected class, so you're going to meet that hurdle. It's when you're trying to talk about what happens after management says the reason that they took an action, and you've got to show that the action they took had something to do with your bases. So for instance, you say, I didn't get the leave request that I made. They denied it. All right, what's going to show is the investigator is going to gather the information on leave. What you're looking for here is whether everyone who is in your protected class didn't get leave. That might make your point. It's probably not going to be that distinct. It's probably going to be less evident because most managers have learned to, they're not making a statement that says, I am not going to see a case, but not usually. So it's going to be more subtle than that. And you probably have to try and show that over a period of time. For instance, desirable holiday or desirable leave days weren't given to any certain period. That's the kind of thing that's going to be looked for. But make sure that you are connecting your bases and the incident. So many times that is where the complainant falls short in their analysis. Or you get to the point where they say, you know what, it really wasn't my race. And I've had them to say that in it. Well, he didn't say anything about my race, and that was your basis. You know, you've got to think about it. And Wanda made a very good point. Sometimes taking the course might help you to lay out your bases. Just because you didn't lay it out well doesn't mean it didn't happen. You just didn't lay it out well.
Right. And that's the thing. We do go into more detail with that when we do the course because it lays out the bases and everything. So you can see that in more detail. So, okay. So again, we mentioned earlier about the burdens and so forth. And so that's what that is on the 3-stage proof and circumstantial case. We talked about that earlier. Okay, now reprisal, retaliation. Okay, again.
One other factor is very important in a disparate treatment claim is the comparators. You're going to be asked to provide a comparator, you know, who was treated more favorably than you and establish those bases. That's a key ingredient to proving a disparate treatment claim is the comparator information.
Yes. Yep. Good point. Okay. All right. So the other part of Title VII, we'll talk about the reprisal, retaliation. Federal government, they say reprisal a lot. Private sector says retaliation. Okay. So that means you took some adverse action against a person because of this. And this is how you make out the prima facie case. So if you're going to say, they retaliated against me because I engaged in prior EEO activity. I filed a prior complaint, and this is important, or expressed some form of opposition to discriminatory practices or other exercise of EEO rights, testified at an EEOC or any EEO hearing. Okay, that could be retaliation as well. Relevant management officials were aware of the complainant's prior protected activity. That's a key part that gets overlooked too. They have to have knowledge of it in order to retaliate. Management has to have knowledge.
This is a very commonly misunderstood one. Just because you think they took an action against you. I time and again in an investigation, I have people say, oh, and then they wouldn't let me take this day off either. That's not the retaliation we're talking about. We're talking about the protected activity on which you are basing a claim of reprisal. Protected activity, as Wanda was saying, a prior EEO complaint, standing up for someone else's unfair treatment. They've also recognized now requesting a reasonable accommodation. Those are what you have to do. And that's what so many people are missing when they're filing their claims. I can't tell you how many complainants are missing that whole point. And they say, oh, and then they did this, and then they did that. That's the retaliation. That's not the retaliation we're talking about. You must identify a protected activity.
That's a good point. That's an excellent point. Yeah. So number 3, we said management affected some action that adversely impacted the complainant following the protected activity. So again, Susan mentioned the protected activity and surrounding facts and circumstances raise an inference of retaliatory motivation, either because the alleged retaliation occurred shortly after the participation or treatment of complainant was noticeably worse than before, or complainant was treated differently than similarly situated persons who did not participate in protected activities. And I know your head is probably spinning because it is. But what you want to do when you go through this, take your time, understand it, Google. You go to EEOC's website. They got a lot of cases on there, administrative cases, things you can read, because it takes a lot of practice to understand this stuff. And that's why I said people mistakenly believe you just claim discrimination and that's it. But it is a legal burden. So, Dorian, did you want to say anything else about retaliation or reprisal?
Well, I think we see sometimes people file a complaint and claim retaliation based on the complaint they filed.
Yes.
And the instant complaint, they call it. And if they hadn't filed a complaint, then unless they have some other retaliation, activity that they reference, they're not going to be able to prove their case because they haven't filed the complaint when the activity occurred, or, when the incident that they believe is discriminatory occurred. But we find that a lot. I think, Susan, you would agree with that, right? It's often
absolutely.
claimed.
They say the instant complaint,
Yeah.
but then everything that happened before they ever filed. Well,
That is a good point, because it is misunderstood. It's because of the name.
Conversely, don't think that something you filed 3 years ago and now there's all different management and everything is they're gonna know about your old complaint. They aren't.
That's a good, but it does come up because of the name.
But they could. I mean, I think
they could. Yes,
it depends. Yeah, they could know about it.
They could. You're right. You're right. Even if it's old as dirt, they could know. You're right. Yeah. Again, here we are with retaliation, reprisals, same 3-step rebuttal.
Right.
Yeah. For example, management denies knowledge of complaints prior EEO activity. And again, the pretext. What we call that? Well, sometimes we call it pretext plus, because now it comes back to the complainant. And the complaint has to show by direct evidence of discriminatory motive or by otherwise showing that the articulated reasons of management are unworthy of belief. And like I said, be sure to look at some of the cases on EEOC's website. They have a lot of administrative cases that you can look at. Of course, cases in the general court system, they may be a little bit more advanced because they're come out of the court. So, but if they have pretty good fact patterns, you can read those as well. Just Google it and you can see what constitutes retaliation and reprisal. Okay, so this was just something we put together. Disparate impact, you will rarely see that. We mentioned it earlier. Those are usually the class action lawsuits because they're usually statistical type of discrimination cases that you have to prove using statistical evidence. All right, that's it here. And we just talked about the same thing about the burdens and everything with that. Okay. So that's it. That's it. This is just, like we said, something we just wanted to share with you today, just so that you would understand the discrimination process better and what your burden is. And also as a management official, what you need to be able to respond to justify your business justification for the action you may have taken against the claimant. Are there any other? And then like we said, we offer training on this in more detail so that you could be more prepared with this, because I will be the first one to tell you, I started out as a wage hour labor lawyer. And so that's where most of our cases are built based on numbers and documents and so forth. EEO is very difficult. It is difficult to prove discrimination. It really is. I think people try to act like it's nothing to it. It's just it, but it's very difficult. And you ladies, did you want to say something else about that?
It's a burden, and go ahead, Susan, sorry.
Yeah.
Discrimination claims. And of course, if you have any questions, you know how to reach us at PREEMPT. That's PREEMPTCORP.com. Just Google us. You'll find us. We're out there. It's just like the name says. And we look forward to keeping in touch. You can check us out on any of our social media platforms as well. Take care, and we wish everyone the best. Bye-bye.
Bye.
Bye.
All right. So let me just stop this.